So picture this scenario. You're managing a tight-knit team when all of a sudden one employee drops an absolute bombshell. They've got an AVO against a work colleague. Now, whilst this is a serious situation, you could be forgiven as a business owner of not knowing what you should do. So stick around as we unpack this really tricky situation and guide you through what is a relative minefield towards keeping both your workplace both safe and compliant. So the first step, if you're faced with this situation, is to ask for a copy of the AVO to understand its terms. And next, we need to clarify whether the order was made with consent but without omissions to better comprehend the situation. We need to determine if the AVO is temporary or permanent and what types of contact is covered. For example, is it face-to-face or does it cover all communications whatsoever? Finally, we need to probe the reasons behind the AVO. Now, of course, we need to handle this situation very sensitively, but especially if consent wasn't given, then we need to see if fear of the other party played a role in the AVO being issued. Now, with the AVO details in hand, the next challenge for our business is to ensure that both the AVO and the workplace laws are both respected concurrently. So, can the workplace be adjusted to help both parties adhere to the AVO? Some options might include different work sites or staggered work from home schedules or moving to different parts of the office depending on the restrictions of the AVO. It's also crucial to communicate to the restrained employee that breaching the AVO could potentially lead to employment termination due to the impact on workplace health and safety if the accommodations are not adhered to. Now, if the AVO terms are impractical within the context of your workplace, it might be feasible to consider to start seeking some legal advice about applying for some amendments to the AVO to better suit your workplace situation, assuming that the safety of the person that is protected by the AVO is adhered to. And if accommodating the AVO within the current workplace setup is just not feasible, we may need to consider alternatives such as leave or, at the very much the last resort, termination linked explicitly to the employee's conduct and its impact on others. As we wrap up here, there are some critical action points you should keep in mind. Of course, this is a sensitive issue, and ensure that all discussions and information sharing regarding the AVO conducted with the utmost confidentiality. Be flexible in your thinking and creative in adjusting the working arrangements to be able to comply with the AVO at the same time minimizing disruption and lost productivity. And finally, like any other HR or workplace relations situation, maintaining transparent and open communication wherever possible with all parties significantly decreases the risk of situations escalating. So as you can see, this is a very tricky situation that might be faced by your business. Thankfully, it's also a fairly rare situation in our experience. So if your business is facing a similar situation, or for that matter, any other HR or workplace relations situation, and you want a no-obligation discussion from an experienced HR consultant, please don't hesitate to reach out to the team here by visiting our website at www.ondemandhr.com.au.